This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are talking with Paul Nolette about his book, Federalism on Trial, State Attorneys General and National Policymaking in Contemporary America. Paul Nolette has been a corporate litigator. He has served as chief legal counsel to the Labor and Workforce Development Committee in the Massachusetts House of Representatives, and he is currently an assistant professor of political science at Marquette University. Paul, so glad to talk with you about this important new book.
Hi, Richard. Great to talk with you.
So the title of the book, Federalism on Trial. The question you seem to be raising in the book, though, is what kind of federalism is on trial, and who's doing the prosecuting, and what theory of federalism do they have, and what the outcome of all of this isn't something like conventional theories of federalism that we have, whereby the states are jealous of their powers and prerogatives vis-a-vis the federal government. Something else entirely from our normal, civics perspective is going on here.
Yeah, that's exactly right. And really one of the big points that I make in the book is that, normally we think about, separation of powers and a vigorous commitment to federalism as helping to shrink, regulation and certainly shrinking the federal government and the powers of the federal government. But what I tackle in the book with my specific focus on state attorneys general is to really look at how American politics isn't just about, veto points and all of these areas where it's difficult to expand regulation. That's the typical story, but what I look at is how, in fact, American politics has lots and lots of opportunity points for actors to really, expand policy and expand regulation. So the bottom line is that even though we think about states' rights and federalism as constraining government, I look at how both of those things in this context really have served to expand government and expand national regulation.
So what sparked this? I mean, we have your book, State Attorneys General have sought to become national policymakers and have been successful, and we can talk about the industries where they've been successful in making national policy. But as you were just saying now, we have something unique in American constitutionalism, and we also have something unique in public opinion, I think, in that we have not wanted, and the federal government has not sought to be seen as massively intervening in industries across the board and remaking and reshaping them. And that's, in large measure because of the fights and the competitions within the Congress. But we also have a fragmented decision-making, as you've been alluding to, because of our federalism. And so in a way, in these different areas like environmentalism, or civil rights, they've invited state actors into the process to help pursue and make policy. Now, state attorneys general were uniquely situated to do that in this regard. Yes,
that's exactly right. And, what I really look at in the book is how, state AGs have become far more activist. So bringing lawsuits against corporations and the federal government itself. And I think it's tempting at the beginning to say, this is a story of just AG activists just running wild or something. And that might be part of the story, but it's a lot more complicated than that. And it's really what you alluded to in your question, which is that actually a big part of the story is that the federal government itself has really empowered and invited AGs into the national policy making process in a number of ways. Number one, by giving them additional funds to expand their offices, hire attorneys, and giving them the resources to bring large-scale lawsuits. But also importantly, they've structured federal policy in a way, especially since the 1960s and 1970s, that first gives a lot of power, or a lot of responsibility rather, to the states to carry out federal policy on the one hand, and also made litigation a big part of the policy landscape as well. And so state AGs are right in the perfect place to take advantage of both of those things. The fact that states are responsible for carrying out a lot of federal programs, and the fact that litigation has become such a more important part of the policy landscape.
So help us understand. So the federal government invites state attorneys general through litigation to intervene and to help it make policy or to create new policy. So we have that down. Now but we should say here near the beginning, that's a different model of federalism than what we normally think of. If we think of, say, what Michael Greva has spent endless amounts of time describing on law and liberty of competitive federalism, this is a cooperative federalism model. States and Washington, the center and the periphery, are in effect colluding. I say colluding, maybe pejorative, but I'm trying to be descriptive here, to actually make policy, one on top of the other, to make more effective or more aggressive national policy than would adhere under normal constitutional conditions.
Right, exactly. So what Michael Greva has been talking about, competitive federalism, is one in which the states. It's a picture of the states, competing with one another to attract business, and in order to do that, they need to lower taxes, lower regulation, and get businesses into their states. And it's a much different model than the type of cooperative federalism that's been a big part of federal policies, really, especially since the New Deal, and then continuing from many of the federal programs that were enacted in the 1960s and 1970s. So just to give a concrete example of that, in the environmental area, a number of federal statutes were enacted, starting with the Clean Air Act in 1970, and then a subsequent number of acts dealing with water, air, soil, virtually everything. And this created a huge regulatory regime over time. And it was at that time as well that the Environmental Protection Agency was created and empowered to create even more regulations. But what was interesting about that policy regime, and this is something that's continued in a number of different areas, is that it followed a so-called quote-unquote cooperative model in which the federal government would set forth various requirements, and then the states were by and large responsible for carrying those out. So they would set certain standards for air quality, for instance, and say states need to meet this, but it would be up to the states to actually carry out those policies by and large. And what that essentially did is it put a lot of the responsibility for policy implementation on the states, which meant that the regime in general, all these regulations, you can kind of think of it as federal regulations and then a whole bunch of state regulations that are piled on top of that. So regulation after regulation created under this cooperative federalist system. So you can see how that's a lot different than what Michael Greva is talking about with competitive federalism, where the impetus is to reduce regulation. This sort of system really encourages more and more regulation over time.
Yeah, no, and I go back to the term that I use, collusion, because it is in effect the federal government realizing its own limitations, regulatory law limitations in the Congress that it faces in the presidency itself, and in effect can allow a much more extensive policy apparatus to take root by inviting the states in. It is truly amazing when you think about it. If you think about the idea of governmental accountability, there's really no way to trace for the voter who's doing what. I mean, in effect, Paul Nolette has to write this incredibly informative book, complex, all of the research you've done to trace all these things together. And yet, how do people really know what's going on? I mean, they don't. That's the point, it seems.
Right, and to back up from all the specifics, I think the key point here and the big picture is what you identified, which is, number one, you have this huge expansion in regulation that really has its origins in the particular way that policy is made and the way that federalism works in the 20th century and now in the 21st. And the implication for that for American democracy is huge because, like you said, it's become very, very difficult to know, if you want to say, oh, who's responsible for this regulation and what can we do about it, it's become more and more difficult to actually point the finger and say, oh, that was because of, this was because of Congress, or this was because of the state of New York, or this was this agency and that was that agency. It's become incredibly complex. And so one of the, reasons why I wrote this book is to look at the contribution of state AGs in particular to this process, which has complicated the picture even more, as state AGs have become essentially regulators in their own right and really creating national regulations and national policies in ways that make the story even more complex and in many ways even more concerning when it comes to who's responsible for these policies, and now you have to point in many cases to the state AGs. But a lot of times their roles, their activities go under the radar, so people don't realize that it's actually state AGs that are responsible for a lot of this stuff.
So, Paul, on this question, though, sketch for us, if you would, what have state attorneys general achieved?
Have achieved out-of-court settlements with a number of corporations and areas of the American economy, including everything from pharmaceutical companies to energy firms to financial firms, etc. And in the course of doing that, by bringing lawsuits, litigation against corporations, they've fundamentally reshaped the regulatory regime that covers these corporations in these areas over time. So just to give you perhaps the most famous example of this, and in some ways what inspired me to write the book in the first place when I was really getting my feet wet exploring the lead up to this, was the AG's settlement in 1998 with virtually the entire American tobacco industry, which resulted in what was known as the Master Settlement Agreement, again in 1998. And what this did was really a remarkable example of regulatory policy making. The AGs threatened to sue tobacco companies, saying that their fraudulent behavior had implications for state budgets and state Medicaid expenditures. And so they threatened litigation and eventually reached this massive settlement in which tobacco companies, in exchange for no longer being sued, agreed to pay what ended up being a massive amount of money to the states, payments that are still continuing and that are somewhere around $250 billion, somewhere around $250 billion over time, and also included a number of new regulatory requirements that the tobacco firms had to agree to, including restrictions on advertising, modifications in terms of how they lobby government, and a number of other things as well. And so since 1998, and this is really what my book focuses on. AGs have used that model in policy area after policy area, as I alluded to at the beginning of my statement. So in pharmaceutical companies and energy firms and financial firms, et cetera, AGs have used litigation to try to expand regulation outward.
I want to back up for 1 second because talk about national policymaking. I mean, the master settlement agreement also. So what did the tobacco companies get out of it? It was effectively a cartel lock-in, whereby my understanding is their market share really couldn't be challenged by anyone, even though they're paying out large sums of money, but they're also effectively protected from any future competition.
Right, exactly. So I mean, there were a lot of benefits here for the tobacco industry as well. And I should mention that, the way that the tobacco settlement works, it, in many ways was unique because of the fact that it was a lot easier to get all the tobacco firms, virtually the entire industry, into the room and negotiate with them. And that's because the top tobacco firms controlled, the lion's share of the market. And it's a lot more difficult to do that in cases where there's a lot less market concentration in particular areas. But nevertheless, the strategy has been, and this is part of the reason why it's gone a little bit more under the radar, I think, than the tobacco settlement, is that the way that national regulation has expanded out wasn't just in this big bang, like with one master settlement agreement with the pharmaceutical industry or financial firms. It's been in a series of settlements over time, many of which, I mean, sometimes they range from, just a relatively small amount, a few $1 million settlements, and sometimes they reach into the billions. But one thing that unites all of them is that they combine a lot of new requirements on the businesses that are parties to the settlement. Yeah. And over time, what that's done is really helped to reshape the regulatory regime that these companies have to deal with. Yeah. And so, the story is it looks a little bit different than the tobacco settlement, but the bottom line is the same. AGs want to expand corporate regulation, and they're doing so through litigation.
Yeah, I mean, I thought, thinking about the master settlement agreement, I mean, were all 50 states parties to that, I assume?
It was actually 46 states that signed the master settlement agreement, but the other 4 had previously signed their own state settlement. So ultimately, it was all 50 states.
Yeah, I mean, and when I think about that, though, I mean, and you alluded to this, so it seems to be the success of that arrangement and it is replicable, and you've got those big targets. They have big concentrated power in their market, and publicly, people have come to think of them as being bad. And so the term big tobacco. Or with the pharmaceutical companies, everyone has, I think, not everyone, but there's a suspicion out there that they're not playing honest with us in terms of prices. I think that's been public opinion for a while. And then environmental policy, you've got the big polluters. And it seems to me it really drives this in the sense of policy making, as you talk about, you piecemeal. And the piecemeal strategy, a huge part of that is to sue and settle, where we never actually go to trial. We never actually have a full litigation strategy and courtroom arguments, et cetera. But what we have is, a nice term you have, bargaining in the shadow of the law.
Yes.
But it seems to me the threat there is, and this also illustrates, just how large the government is and how much it's involved in the private sector. The fear is I'm already perceived badly or with mixed opinion and public opinion. I could lose, and if I lose, then I get something like the death penalty regarding government contracts, and I'm just shut out, and it basically kills my firm. And so I end up settling all of these different lawsuits, and that's a big way of actually crafting new policies, in particular for the pharmaceutical industries, which you talk about with regard to pricing and also advertising. They've, all the ways that we interact with pharmaceutical companies have been made by the strategy I get from your book.
Right. Yes. And so the incentives for companies to actually go along with this, because you might think at the beginning, well, why is it that companies are agreeing to all these new regulations that are in these settlements, and agreeing to pay out these often massive sums of money to the states? And with a lot of these lawsuits, the incentive is the fact that in public opinion, as you alluded to, they're already under a lot of fire, and by being able to settle claims, it they can say, look, we're not going to trial, we're not going to risk losing and potentially have our names dragged in the mud. Mm-hmm. Instead, we want to get this out of the way, and that also helps with shareholders as well, who get very nervous about these lawsuits. But ultimately, what that ends up doing is it gives the prosecutors, the AGs, a lot of power and a lot of discretion to get these piece by piece regulations in place. And so, one example of that, and you mentioned this in your question, but with the pharmaceutical companies, a big part of their market is government contracts, within Medicare and Medicaid, the government and other government health care programs. And the leverage that they use in order to get these settlements is to say, you know what, if you don't sign these settlements that were, are part of the threatened litigation that we're using against you, then we're going to shut you out of these government contracts altogether. And some have called that, essentially the death penalty for these companies, because you're taking a huge chunk of their revenue away by doing that. And so that gives a massive amount of leverage to AGs to get all sorts of regulations in these settlements. And one concern that I'd mention about this, in addition to the accountability problem and the fact that this is expanding regulation out in a very subtle way, is that in a number of cases they can actually do things through regulatory settlements that even government agencies regulating wouldn't be able to do. So, to give a concrete example, in the pharmaceutical litigation, for years, advocates in Congress, critics of big pharma, had tried to get all sorts of bans on drug advertisements, both on TV, on print, and trying to really restrict what and how pharmaceutical companies could advertise their products. But one of the problems that they ran into was a constitutional problem. Well, if the pharmaceutical companies are telling truthful stories about their products, reaching out to potential consumers, then that very well could be protected free speech, corporate free speech. And in fact, a number of courts have characterized drug advertisements as a form of free speech. So, if Congress or a federal agency, the FDA, let's say, tries to ban these advertisements or regulate them in a way that de facto bans them, then that raises a serious free speech problem, and one that can be litigated by the companies that are subject to that regulation. However, what's different about the regulation that's in these settlements is that AGs can use their huge leverage over these companies to say, you know what, if you don't want us to sue you, then you have to agree to all of these advertising bans and advertising restrictions. The same exact thing that a lot of the critics of Big Pharma were trying to do through through legislation and traditional regulation. And because they're lodged in an agreement, in a out-of-court settlement, these things are essentially immune from judicial review because it's an agreement, even if it's an agreement that really is more akin to a gun to a head a gun to the head of the companies, saying agree or else we're going to throw everything we have at you.
Yeah. It's interesting here. It sheds light on something we all knew. How quickly the drug companies kind of fell in with Obamacare, in the sense of they actually know if they don't fall in, they could be shut out from a lot of government contracts and their revenue streams dry up and just piecing. And I thought of that as I was reading your book. Interesting though, and just thinking about. I mean, quick question. I mean, this is bipartisan stuff we're talking about here. I mean, this is, I mean, and I think Bill McCollum, I think the Florida AG has been pretty active here, even though he's fairly conservative and was involved in initiating litigation against Obamacare. But an attack by Congress on this activity, I suppose not necessarily the sue and settle, but in some way, the compact clause within the Constitution, this might be a really dumb question, an easy question, I don't know, but isn't there some way that Congress can vertically attack these agreements among states to regulate industries outside the sphere of federal regulation? Now, I guess this is all, as we were talking about, the government has invited them in, so maybe that stops it. But, the master settlement agreement, that seems to be a shining example of a compact that the federal government could have absolved if it wanted to.
Yeah, and I'll say at the outset, courts have been quite skeptical of arguments because, in fact, constitutional arguments in court have been made that something like the master settlement agreement and other types of these large multi-state settlements constitute a violation of the compact clause of the Constitution. But courts have by and large rejected those arguments. So really, the main way that Congress could put a stop to this is to really start saying, look, AGs, if you're going to start making what are essentially nationally applicable policies through the settlements, then you need to either get our permission to do so, or otherwise just Congress can regulate in that area itself, and through the supremacy clause of the Constitution, essentially preempt what the AGs are doing. And I should back up and clarify one point here, which is to say that sometimes when AGs are bringing lawsuits, it is based upon federal law.
Yeah.
They're bringing lawsuits based on the Clean Air Act or Medicaid statutes and that sort of thing. But other times, and this goes for drug companies and energy firms and many others as well, they're basing their lawsuits on state laws. And there have been a number of cases in which AGs have sued drug companies, under state law for things that the feds have already approved. So there might be a type of advertisement or drug labeling that the FDA has said, no, that's acceptable. We've reviewed it, and you can go ahead with your advertising campaign and the sale of the products. But then the AGs have stepped in and said, well, regardless of what federal law says, we think what you're doing is illegal under state law. And so, and they've used that as the leverage to achieve these settlements and to achieve regulation that goes even beyond what the federal government has required. And so those sorts of things Congress could preempt. They could say, these sorts of state lawsuits are preempted by a regulatory regime that we're going to determine and that applies everywhere. But by and large, Congress and agencies haven't done that. And, they've let AGs, go ahead with these lawsuits. And not just that, but in fact, they've continued to encourage these lawsuits and really empower AGs over time. And I think a big part of the story there, and this is what we were talking about a bit at the beginning, was that Congress sees the AGs as, able to essentially be regulators on the cheap.
Yeah.
So, Congress doesn't have to expend any tax money for the AGs to do their thing, and to essentially act as regulators on the state level. And the same justification more generally is in place for cooperative federalism and that whole model. So it's a model of saying, hey, we're going to do all this stuff. We want to tackle, pollution and drug regulation and all this kind of stuff, but we're going to foist a lot of the responsibilities on the states because then they don't have to pay for it.
Yeah.
And so this is, all of this is to say that there are so many incentives for Congress to continue this, continue empowering and inviting AGs into national policy making, that I wouldn't expect it to go away anytime soon.
Yeah, I think, excuse me, just listening here, this cooperative federalism model goes all the way down. And so, you can also look to, there have been some recent books. James Buckley has an interesting book here, Saving the States, on, the idea that state government itself has become a grant receiver of federal dollars, and so the federal government has basically not even hired new workers for the last 40 or 50 years, or new bureaucrats, because it largely ships everything to the states to administer. And state employees have of course ballooned during this time. But what are they doing? Largely what the feds want them to do. Your book in a way is kind of a legal litigation type equivalent of that, I think. And, I suppose we could have Michael Grave in, and he could talk about the ways in which jurisdiction requirements, Erie requirements, all of these sorts of things that came in with the New Deal that altered states' ability to reach corporations, or giving them a more expansive way, prepared the way for this. So it truly is, just a shift in federalist thinking and constitutional thinking. That's at work here, and that prepared the way for this, massive amount of power.
That's exactly right. And at least my big point in the book is to say, if you really want to understand contemporary cooperative federalism, then you really do have to look at what the state AGs are doing. And a big reason for that is that it goes even beyond what other types of state regulators are doing, state agencies and other types of regulators on the state level, because the AG's way of policymaking, their methods of policymaking, particularly through multi-state litigation and these big multi-state settlements, affect national policy in a way that any one individual state and any one individual state regulator can't do. So at least my argument in the book is to say these state AGs are an example of cooperative federalism in the modern era, and a really important one, in part because the way that they're regulating through litigation actually even has broader effects than what you usually think of as states having in the federal system. So, unlike a state, even like New York or California, that institutes a new rule that might be able to be at least somewhat contained within the borders of that state, the AGs are very self-consciously and explicitly making policy for the entire nation through these settlements. And so that's my pitch here to say that AGs are a key part of the cooperative federalism system, but even in many ways go beyond it by really becoming national regulators in their own right.
So if we can't look to Congress, we can't look to Congress to discipline the administrative state, seems to me, and as you document, the incentives for them to do something here, with many of them being very closely tied to the agenda of their state governments, and of course being impacted by what they're hearing there, they're probably not going to chasten what AGs are doing also, and even how could they really? I mean, there's no public opinion outcry on this, so it seems maybe that could shift our focus. I mean, one question here is they did try. I mean, there was an attempt by state attorneys general to replicate this against the gun manufacturers.
Yes.
And they failed. I mean, I guess, or it seems to have stalled. It seems to me the dominant reason is that their legal theory was less than airtight, to put it mildly. But also, it seems to be going back to public opinion. Public opinion doesn't really look at gun manufacturers as evil, or people who are like tobacco companies profit from our sickness or something. Gun manufacturers, it seems to me, people kind of really kept in line the individual responsibility ethic. Nobody is forcing you to do stupid things with a gun or bad things with a gun, and so they failed there. Did you think about that? Because you don't really discuss that in the book, but it was on my mind reading it.
Right. Yeah, and it's a good point, because the gun manufacturers were really one of the first industries after the tobacco settlement that a number of AGs tried to regulate, particularly the AGs of New York and Connecticut, Maryland, and a few other fairly liberal states, quite liberal states, in fact. Tried to go after the gun manufacturers who, like the tobacco manufacturers, are a relatively concentrated industry. And so there was an attempt to do something like the Master Settlement Agreement with guns. And I think the difference between that case and a number of the other subsequent cases that we've seen is that by going after the gun companies, and the AGs really waded into a very controversial area of gun control, which is essentially what they were trying to do in these settlements. And they were very explicit about this. This isn't about the money. The money is not the concern here. It's trying to essentially get gun control through settlements.
Yes.
But that ended up getting a lot more attention. And there was a lot more public outcry about that because it touched upon such a controversial political issue. But I think the difference between that and a lot of these subsequent cases is that, things like litigating the average wholesale price of prescription drugs is not exactly something that's going to get, people fired up in the same way that gun control is.
Yeah.
And so I think the AGs have used that to their advantage by using these relatively obscure avenues to expand regulation in the pharmaceutical industry and energy firms and so forth in ways that has really minimized the potential controversy here. So to circle back to your original question about, well, what could be done to push back against this activity, I think is in large way more awareness about what's going on. Yeah. I mean, a lot of this stuff has just been completely under the radar. And there is some indication that people are paying more attention. There was a series in the New York Times just recently, over the last few months, that looked at the collaboration between AGs and plaintiffs' lawyers and a number of other groups as well, to try to influence state litigation and influence the regulations that come out of that. And it shines a spotlight on the fact that, a lot of this stuff is not just being driven by the AGs, but by the AGs' allies, who have increasingly lobbied AGs to bring lawsuits against particular companies, because they realize where the action is now.
Yeah.
If you want to get regulations in place that you can't get through Congress, well, turn to your state's AG, because that's going to be a good avenue to do it. So all of that's to say that I think there has been growing attention to AGs as it's become clearer and clearer that they're playing a major role in American politics, but I think we still have a ways to go on that. that ground.
Yeah. Now, I mean, we haven't even talked about this. Is their use of trial lawyers, expensive private firms and their outfits to which they would have to use to conduct this litigation, and to be effective and all of this sort of business in order to, really go after what is a complex litigation. But that, of course, these guys are making a lot of money of state government. I mean, the trial lawyers made tons of money in the master settlement agreement, and that seems also to have been kind of under the radar in the sense of that, another opportunity of collusion of profit between government and the private sector. Kind of, truly is a model of roving bandits, it seems to me. But on this question of chastening, or at least discipline, I mean, we have seen, I think, with the Obamacare litigation, 26 states, that seemed unprecedented to me. We've seen states fighting the EPA and this raft of rules that have come out of Massachusetts versus EPA as well. And it seems to me, and also, with the Boeing thing, I mean, that seemed to me that the right to work states really understood what was at stake there. And so this kind of raises to my mind, there's maybe existential survival interest might be too strong of a term. But really a clear realization that there are states, and we said this is bipartisan, but the blue states really profit from this and make their political hay out of this. But this is really a cost to a lot of states that are trying to compete and attract business and attract citizens in, places like the Midwest, which seems to me an interesting part here. And this is all in play, and this might be really a good way. And Grave has written about this. The sectional, competitional rivalry amongst states is a huge part of the unwritten story of making competitive federalism work, and maybe that's coming back into play somewhat.
Yeah, and somewhat, I would say, because a lot of these settlements still remain bipartisan. I mean, Republican and Democratic AGs alike joining these settlements. Although, as I find in the book, I mean, a lot of this is being driven by the more liberal Democratic AGs. I mean, initiated by them at least, and then Republican AGs join in, have traditionally joined in after the fact.
Now let me one question there though.
Yep.
On the Republican AGs joining in. But that is, of course, the model of competitive federalism. If the spoils are going to be split, you might as well go ahead and get in on it, or else face the voters' wrath. And why wouldn't you in that regard? Kind of the same way, if there's a federal grant announced, what do you have to lose by not getting in on it? So I don't know. Is that at work there? Maybe.
Oh, absolutely. Because and to give an example of that. Back in the time of the tobacco settlement, one of the biggest critics of the tobacco settlement was actually one of the AGs, Alabama AG William Pryor, who's now a federal judge, but was AG at the time, and he was a big critic of the tobacco settlement, saying this is, AGs going well beyond what they should be doing. This is regulation through litigation. And we really need to put a stop to this. But even he ended up joining the settlement because the incentives were just too great not to. Because after all the regulations that are part of this settlement were going to happen whether or not, Alabama joined the settlement or any one state joined the settlement. So at least Pryor actually was a big part of the story, and I think helps to get to this question of pushback on this stuff. Because even though Pryor ended up joining the tobacco settlement because of the incentives to do so, he subsequently helped found the Republican AGs Association in 2000. And the purpose of that was to say, well, we're going to have this organization where we specifically try to elect more Republican AGs and also discuss ways in which we can, go about our business in a much different way than what a lot of the liberal AGs have done, the pro-regulatory AGs. And that strategy has reached some success. In fact, just after 2014, Republicans have the highest number of AG seats that they've had in decades. It's up to 27 right now, where Republicans had generally been in the minority in terms of all of the state AGs. But also, it's in some ways started to, push back on this idea that, AG should just use settlements, as a regulatory device, essentially regulation through litigation. And like I said, there still hasn't been a whole lot of pushback on that, but it's starting. The Oklahoma AG had some real concerns about that big $25 billion financial settlement a couple of years back as being another example of regulation through litigation.
The mortgage settlement.
Yeah, the mortgage settlement. Okay. And there was some pushback there. But, generally speaking, though, it's still been relatively muted. But there has been some shift in terms of the rhetoric about this AG litigation as more and more attention is put on it.
Yeah. Well, we just had the Standard & Poor's settlement where state AGs participated in well and all received various sums of money. What do you see out there going forward? You talked about Dodd-Frank being another instance of this and inviting litigation and regulation by litigation, et cetera, in the book. But what are the next shoes to drop, you think, in terms of investigations that are going on or settlements or anything like that? What should we be on the lookout for?
Yeah, well, number one, the pharmaceutical and environmental lawsuits and settlements still continue. And they've continued. They were big in the George W. Bush administration when AGs really self-consciously, at least liberal AGs, said, well, the Bush administration isn't doing anything, so we're going to step in and fill this regulatory gap. They were quite explicit about that with their litigation. But it's also continued in the Obama administration. So one issue that's actually quite interesting, and I think would also happen in any subsequent Democratic administration, at least with an environmental protection agency that is looking to expand regulation, are so-called sue and settle agreements in which state AGs and environmental allies as well file lawsuits against the federal government directly, like the EPA, and then very shortly after settle the lawsuit. And in that settlement is a bunch of requirements for the EPA to expand regulation. And so these sorts of sue and settle strategies actually have gotten the attention of Republican AGs who have criticized these. But I think it's one thing to be on the lookout for, I think, throughout the remainder of the Obama administration and depending on the nature of the next administration as well.
So you could see procedural collateral attacks on these judgments or things
yes,
like that?
potentially yes, and more demands for a spotlight to be shown on these settlements. And I'd also say that one big thing that we have seen during the Obama administration that we didn't see previously, certainly not even in the previous Democratic administration back in the 90s, is that Republican AGs have been a lot more aggressive in challenging regulatory expansions like Obamacare and environmental regulations in the courts as well, bringing a number of arguments, both statutory arguments, constitutional arguments. And that sort of Republican AG activism we haven't seen in the past. And it's something that's really grown as well. So in terms of what I see and where this is all going, is ultimately I can see this becoming even more polarized among the AGs themselves in terms of what they are trying to achieve through litigation. And it really helps to indicate this broader story of federalism, which is going on here, which is that it's important to realize that this isn't a story of, the states as some coherent group versus corporations or the federal government. It's in many ways blocks of states with very different regulatory outlooks. And I think that dynamic and the kind of polarization between these two groups is something that's going to continue to expand through the rest of the Obama administration and into the next one as well.
Interesting. So maybe, so that's good. It seems like there's some promising developments here. We've been talking with author Paul Nolette about his book, Federalism on Trial. Paul, thank you so much for your time today.
Thanks for having me.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.